Thank you for joining us for today's live stream. Today, we're going to tackle the challenges of AI in business law, specifically how using AI creates new legal risks. Many C-suite leaders, as well as their employees, have no idea what they're doing nor the ramifications of what they're doing. In order to tackle this weighty subject, I have chosen two subject matter experts to help us figure out this emerging challenge today. Mr. Gary Kibel has over 2 decades of legal and business experience with an MBA from the prestigious Binghamton University and a JD from Brooklyn Law School. He is currently a partner in the Privacy and Data Security Practice Group of Davis Gilbert, LLP. Our second speaker is an AI best practice visionary, a CRM expert, and the CEO of startup Sentia AI, Mr. David Forder. To our listeners, thank you for joining us today. And if any of you have any specific AI or legal risk questions, please add it in the comments section. We're on Twitter, we're on YouTube, we're on LinkedIn, and we're here. So we also thank you guys for joining us, and please check out sentia.community for the latest in AI news, AI tips, AI tricks, training, and of course, AI discounts. So with that in mind, Gary, would you please tell us a little bit about yourself, and then we're going to jump into the questions.
Sure. Thanks very much, David. I'm happy to be here with everybody. So as David mentioned, I'm an attorney with a law firm in New York, Davis Gilbert, and I've been practicing in the areas of technology and media and privacy and data security for a number of decades. And there are always new trends and changes in the industry. 20 years ago, when I was doing privacy work, it was a teeny little part of the mix, and now it's a massive part of the mix. And AI the same way. It's really starting to take over in terms of the conversation, both for internal operations at organizations and consumer-facing businesses. And there's so many different AI issues that it's very, very exciting to deal with this right now.
You know, speaking with that, that actually brings me to my very first question to you, Gary. So there was 2 AI-specific laws that have now been passed by states in the United States, not the feds, but the states have actually gone ahead. So can you explain what these new laws are and what they mean for the other industry? And like the states that are working with these 2 states, how do they deal with it when they don't have that AI law, but that state does?
Sure. So this is sort of following the model that happened with privacy regulation in the US, where the federal government has not come out with a law and states are jumping into the void. I think it's happening much faster in the AI space than it was with privacy. It took, a decade or more for things to really move along. So with AI, we now have 2 states that have enacted unique AI laws, Utah and Colorado. The Utah law is fairly straightforward. The Utah law really focuses on transparency for consumers. They want a consumer to understand if they're interacting with an AI feature instead of a human being. And that's actually not a radical new requirement under the law. There's actually been a chatbot law in California for well over a decade that would require disclosures to a consumer if they're interacting with a chatbot. You need to explain to them that it's not a human being. So the Utah law, I think, is fairly easy to comply with. The Colorado law is much, much different. This is a really meaty, comprehensive law with many, many new requirements. Firstly, the law doesn't take effect until February of 2026. And that's because there's a lot of new requirements under this law. It focuses on controlling algorithmic discrimination in consequential decision-making for consumers and individuals. So that could be, what's a consequential decision? Could be about employment or health or legal issues or many other things that are really going to impact someone's life versus what show to watch on Netflix or which shoes to buy, online. So the law requires a lot of new obligations on both the developers of AI platforms and then what they call the deployers of AI platforms. Those just could be companies that are putting out AI features to their consumers, but it's been developed by somebody else. And whether you're a developer or deployer is going to determine what obligations you might have. Those obligations might be greater transparency to the consumer about what's happening and giving them rights to opt out of certain consequential decision making. You may have obligations as a developer to make disclosures to the Attorney General of California, telling them about how your AI technology works without giving away any trade secrets. And there may be obligations to conduct what we call an impact assessment, to analyze what's going to be the impact on individuals when they interact with this AI feature. The one positive thing about the law is that there's no private right of action, meaning that individuals cannot sue for a violation of the law, which means class action lawyers cannot sue for a violation of the law. And the last thing I'll say before I move off of the Colorado law is that it does have a carve out for small businesses. There's a metric for under a certain number of employees and things of that nature, so that it would not apply to a mom and pop organization. But if you are a developer of an AI platform, or you're a corporation that's going to deploy an AI platform, you really need to look at this Colorado law soon.
That makes sense. I mean, the transparency is one of the things that we really struggle with, is when you're citing those software agreements, what you're signing is often not what you think you're signing, and who's actually playing with your data is pretty darn scary. So I guess you kind of answered almost my second question on the data privacy, and that's can the other states, the other 48 that haven't actually done anything, or the feds, can they regulate without new laws? And that goes back, I'm guessing, to the data privacy stuff that you were mentioning earlier. So there is some protection in place. It's just it may not be AI specific. It might be data driven, right? Is that how it's going?
Yeah, exactly. I often refer to it as sort of a backdoor to regulating AI, because there are ways that AI can be regulated right now. If you're familiar with the privacy industry, you know that California was the first state in the US to have a comprehensive consumer privacy law, the California Consumer Privacy Act, CCPA. Under that law in California, the CCPA, they can regulate automated decision-making technologies. And that's sort of what AI is.
That's
really what it is. And so there's a new California privacy regulatory agency that's being built up in California, and they are issuing regulations under their privacy law. They're going to come out with new regulations about automated decision-making technologies. And those regulations under the privacy law will then actually be a way to regulate AI to some degree in California, at least with respect to how it processes personal information. So that's one backdoor into AI regulation. On the federal level, I mentioned that there's no comprehensive privacy law on the federal level. There's certainly no comprehensive AI law on the federal level, but the Federal Trade Commission has incredibly broad authority to regulate deceptive or unfair practices. Now, you can drive a truck through those lawyer weasel words of what's deceptive. And they use those two words to regulate everything consumer facing, from advertising and privacy and influencer marketing. Anything you can think of can be deceptive or unfair. Deception is when you have an omission or you misrepresent something to a consumer that's material to their decision making. And unfairness is something that is likely to cause substantial consumer injury. So again, that's everything. I mean, if you're doing a car commercial and you say a car goes 0 to 60 in 3 seconds, but it really takes 10 seconds, that's deception. I think the FTC would say if a consumer is interacting with an AI feature and they think it's a human being, but it's not, that's also deception. So there's another backdoor into AI regulation where the federal government can come after you right now based on what you're doing in the AI space. And the last thing I'll say on that point, David, is that they've sort of done this already. There was an enforcement action against the pharmacy chain Rite Aid for using certain biometric features to identify bad actors when they were in the store. And it was sort of an AI biometric tool, and it wasn't working properly. And so the FTC said that was an unfair practice because consumers were being harmed because they were being unfairly tagged as a bad actor when they were in a store when it was just the AI biometric feature not working properly.
That's interesting. So I'm going to ask you about European laws in a second on that, because I know in England, it's especially London, you can't go to any corner without having some CCTV camera watching you. Same thing in China as well. So it'd be interesting how they're dealing with those laws first. So one of the things that I look at, and I'm going to have David Forder answer this from a business perspective, but why isn't the federal government jumping ahead of this? Because otherwise you're going to have all these hodgepodge, 50 states having 50 different laws, and you've just explained two, and they're very different. And then California, we know that they're going to get their hands in here somehow. So if I'm a CEO of a company, what is it that I should be keeping me up at night? Do I try to look at the data privacy laws and mirror that, hoping that that's close? Or what is it that I do to mitigate my risk in such an important area when there's no legal precedent for me to go on? What is it that I do to protect myself as a CEO? And let's say Dave Forder comes to you and says, Gary, protect me. What is he going to do? What are you going to do?
First, you're going to hire a great outside legal counsel to protect yourself.
Davis Gilbert.
It really is a challenge these days. And seeing what happened in the privacy world is exactly, unfortunately, what I think will happen in the AI world. There are those begging Congress to come up with a comprehensive AI law so that we can stop this in its tracks before we end up with so many different inconsistent AI laws with different obligations. That's happened in the privacy world, and the industry is begging and pleading with Congress to implement a comprehensive privacy law that would preempt all the different state laws out there. And I think there's about 19 different state privacy laws now, comprehensive consumer privacy laws. It's making compliance an absolute nightmare, and it's really, really challenging. Again, to the analogy of privacy, as we sit here now, 5 are currently in effect. 3 more are taking effect in about 3 weeks. More are taking effect in 2025. And Congress still hasn't, got off their butt to enact a law to preempt all of these. So I think the pleas from business are going to grow louder and greater. The FTC was once testifying in front of Congress within the past 6 months, I believe, and said something such as, we missed the boat on privacy. We shouldn't miss the boat on AI. But I think it might happen. We're in an election season. It's harder for Congress to get things done. They're focused more on political issues. There's always something that's going to make the left and right disagree. I see that happening in the privacy world right now. So while I love it for Congress to come to the rescue, I don't see that happening soon.
Got it. So that brings me to the kind of the European thing. Traditionally, there's 6 to 12, maybe 18 months ahead on the legal stuff, and a lot of the stuff behind the United States. So pursuant to the privacy stuff and the data privacy you're talking about, would there be any merit to look into what they're doing in Europe right now as kind of a harbinger of what the U.S. might be going in that direction? Or is that some way to kind of protect yourself? I mean, there's no guarantees here, but again, we're talking about risk mitigation, both on the business and the legal front. What do you recommend that we learn from the Europeans?
Yeah, I mean, I remember back in the early days of GDPR, we were all criticizing, oh my God, Europe's coming out with this big privacy law. It's so difficult and it's going to be bad for business. Now versus what's going on in the US, I'd much prefer that model of having one standard that you can look at. And it may be a difficult standard, but at least it's one standard. And the EU has taken the same approach with AI. So they have implemented the EU AI Act. And there's many different parts of the law, but I think what's important for our listeners right now is that it puts AI technologies into 4 buckets and then regulates them differently based on those buckets. Firstly, there's what they call general purpose AI. It's really just using AI in the back end for things that, to borrow the Colorado language, don't make consequential decisions for consumers. Then there's low risk AI services, then high-risk AI services, and then unacceptable AI services. And in that top bucket of the unacceptable ones, those are prohibited, that you cannot use AI to make a real consequential decision about an individual's health or legal or something really important like that. But based on where you fall within those 4 buckets, you'll have different compliance obligations, you'll have different disclosure obligations, different impact assessment analysis you need to do, different rights that you need to give to consumers. So I think that is helpful. While that top bucket of just completely unacceptable makes me a little bit nervous, I don't think we should say that something is completely illegal in terms of AI at this early stage. I think it at least gives a framework that hopefully U.S. regulators will look at, that there are certain AI functions that are just plain vanilla. It's just technology in the background helping to automate things. We're all using technology right now, and we're using automated systems to target advertising and do other different things for us. And that's really not a danger. But I think the concern is that when a consumer believes they're interacting with a human, there should be greater transparency. Or when AI is making, again, a consequential decision for an individual, such as whether or not you're going to get a good health insurance offer or whether or not you're going to get an employment offer, that AI should be regulated there, because we often talk about the negative and unintended consequences
Bias.
of data analysis. That, I like to look on the better side of humans. We're not trying to discriminate against people, but the data sometimes may result in discrimination inadvertently, and that needs to be regulated.
And that's a huge lawsuit waiting to happen.
Yes.
I guarantee you that one's a bad one. All right. So, let's talk about the focus of a user of an AI service. So I'm a user. I purchased an AI service. What should be the focus of that? What is it that, sorry, go ahead.
Yeah. So I think the first thing as a user of an AI service is, and this may not seem too sexy, read the terms and conditions about the platform.
Doesn't everybody, Gary? I thought that's what everybody did. It's like, where's my manual? Please. I'm not going to open a page, so I read my manual, right?
I'm sure everybody here doesn't just click accept. They scroll down and read the legalese on the page for every single service and website.
Everybody's a JD at heart, Gary.
Exactly. But if you're in a business setting, as opposed to a consumer setting, you do need to read those terms and conditions, because you need to understand, what is this AI service going to do with your data when you input it into the service? And what rights are they giving to you to the output that is generated from the AI service? And what, if anything, are they going to do to protect you if things go wrong? And I think that's really important in a business setting. We know that consumers will not read the terms and conditions. They will click accept and move ahead. But if you're going to use it for a business purpose, you need to understand how that AI platform is going to use your data.
I think that's important. And then I guess it's like, who actually is going to read that document, Gary? I don't have my in-house legal counsel to do that. So am I trusting my trusty CIO's protege engineer to do that? Or,
I mean, look, this is not a sales pitch. Of course, lawyers are much better at reading terms and conditions, but I think someone knowledgeable with how technology works can look at it, and while they're not going to be analyzing the limitation of liability section, they will analyze the data usage section and the rights section and understand. For example, this is a true story. I had a client that wanted to use an AI platform in an HR setting, and we looked at the terms and conditions, and it allowed the platform to use the HR data for other purposes.
oh boy.
And we realized we can't use this AI platform for HR if they're going to be using the data for other purposes. So looking at the terms for some basic information like that would be really, really helpful. And you'll also get a sense when you look at terms, if the AI platform is sophisticated, if this was developed by a company that knows what they're doing and is taking a real practical approach, or if it's some company that just copied and pasted AI terms from some other platform that was unrelated and doesn't make any sense.
That's a big difference. So I'm going to ask one more question before we jump into Mr. Forder. So we talked about the focus of a user. Let's take the opposite tack. So now I'm the developer of an AI service. What is the differences there from a legal perspective, and how do I probably a lot of nefarious players that are using legalese to protect what they're actually doing with the data? And then I guess the other question, I'm going to bring this up with David, what happens if I'm have my rules and stuff for AI in place? I'm bought. So now that next company, are my laws precedent, or can that new company change it to whatever the heck they want, regardless of what was signed before? So I guess the developer of an AI service, that's my question to you. And then we're probably going to have to ask Dave the same question.
Sure. So when you're the developer of the service, you want to both protect your company, but be reasonable with the consumers so that you can get business. So it's a combination of drafting terms that are protective of the company, but also very realistically explain to the users what's going on. So on the one hand, on the legalese side, you want to limit your liability and disclaim warranties and be able to litigate in your preferred jurisdiction. But you want to say to the user, perhaps, and this is the way OpenAI does it with ChatGPT, about how we're going to use your input data, whether we're going to use that to train our AI model or not, and what rights you have with respect to the output data. The way ChatGPT says it is that as between the two of us, as between OpenAI and you as the user, you own the output. But as with respect to you and the rest of the world, we don't know, because our output may infringe someone else's rights. That's the way AI works. We don't know what's going to come out in terms of the output. And then in terms of future proofing, to your point, David, because every startup wants to be acquired and sold in the future, it's having sound agreements that make sense, make sure assignability provisions work well. It's really doing sort of pre-due diligence on your company before a sale, so that you know that your house is in order, so that when the acquirer comes along and opens up the Brinks truck and throws tons of cash at you, they're going to be happy at what they're buying, and they're not going to be terrified at what they see.
Well, I think that's a great segue into David. But before I do that, Gary, would you be so kind as to tell us, how do the hordes of followers that want to gain your AI legal knowledge get in touch with you and access your services? How do they do that?
Well, if they want to join the other hordes of followers who are already following me, a number of ways. You can find me on LinkedIn, and on our firm website, we publish a lot of articles. So the firm website is dglaw.com, as in davisgilbertlaw.com. If you look under my bio, you look under insights, you will see lots of different articles and newsletters there on these topics, and you can subscribe to them to get more.
Fabulous. Well, I appreciate that, Gary. So at this juncture, we're going to head into Act 2, and we have Mr. David Forder, the CEO of Sentia AI, and a longtime Salesforce partner as well. Thank you for joining us, David. And would you please tell our listeners about your background and why it is that you've been using AI in CRMs?
I will, David. Thank you. And thanks, Gary. But there's actually a question before I sort of take over the conversation for a while. There's a question from Eva in LinkedIn, Gary, that relates to AI, music copyright, and likeness, which I presume is image copyright. Have you got any comments on that? I don't know if that's your field as well, but what's the latest? Because I know there's been some Supreme Court cases around those issues. Did you get my question, Gary? Am I muted?
Sure.
I hear you. I'm
okay.
Did you hear the question?
Yes, I got the question about music and copyright. And forgive me, I think my LinkedIn was in the background simulcasting, so I was getting it from both ears. So there's lots of lawsuits already going on right now in the AI space because of what I just said a moment ago about the output. Don't know what the output's going to be. And the output could very likely infringe someone else's rights. If you said, give me a photograph of a blonde pop star, performing a concert in front of, 80,000 people in a football stadium, you're probably going to get an image that looks infringing and might look like
Taylor Swift, right?
Yeah.
Because
So,
that's going to think that's what you want.
Exactly. So it's sort of that concept of bad data in, bad data out. So I work with a lot of clients that use AI in terms of the creative industries. And we always teach them, don't ask for a problem. Don't ask what I just did in terms of that input. Ask more generic inputs. And if you ask for generic inputs, you'll get more generic outputs.
Gotcha. All right. Well, I'll talk for a little bit now, Dave. So my name's David Forder. So we're both Davids on the webinar today. I'm CEO and founder at Sentia. Dave touched on this, but basically we drive huge improvements in enterprise software by introducing a deeply integrated AI tool. Lots of automation, user-friendly interfaces, and we work across Salesforce.com, NetSuite, Microsoft Dynamics, and others. And what I'm going to focus on, I think, is risk around the legal framework that's in place rather than the actual laws. Part of our offer includes an AI risk advisory service. So in case of in the chance of some business, we definitely can help businesses with it. But let me speak to that. Dave, I'm going to preempt the first question on the list here about how cognizant companies should be around risk and AI. And right now, it's obviously AI is used pretty widely. It's pretty much uncontrolled use in most businesses, and I'll explain what I mean by that. And it introduces an enormous number of risks. Some examples: Samsung just banned the use of generative AI globally. through all of their organizations because some of their coders were using ChatGPT to help debug some code. Samsung discovered their source code's out there in the world. And so it's now sort of available through ChatGPT to the public, which was a big fail. All heard about lawyers being disbarred when AI invented fake case law. That's a challenge. Zillow, a property business here in the States, lost $300 million. They used generative AI to revalue all of their properties. They ended up selling a whole lot of homes for less than they were paying because they just they had unfettered use of AI. And there's lots of compensation cases now touching on something Gary mentioned, where AI was used in recruitment and inbuilt biases led to discrimination. So it's a risk. McKinsey put a report out just last month that around 70% of staff in businesses are using AI for work purposes without the business actually knowing or controlling that use. So serious risks, and businesses need to start paying attention, Dave.
That's a great intro, and I appreciate you talking into that. One of the challenges I see right now is there's so many bad AI stories of AI gone wrong, because it's kind of exciting. But when you see all these companies changing their staff structure and what that means, it means that they're using AI and it's obviously working, or they wouldn't be changing things, right? So what I think they're doing is a lot of these people are hiding what they're doing because that's their advantage, versus the negative stuff is what we see, and we see the most of. So I guess from an operational perspective, Gary was talking about the larger companies are maybe more ethically and more legally, so they got the documentation a little bit better. So if I use like MS Copilot, for example, have I mitigated the risk? I mean, I can trust Microsoft, right? I use Microsoft products. I can trust them, right?
Yeah, the answer is no, you haven't mitigated the risk, and I'll tell you why. There's a certain element of risk that using a paid service like MS Copilot does resolve, but there's a long list of others it doesn't, so I'll talk to those. Most likely, most of the time when I get a question about, well, what's really the risk in using AI, people will say, do me using Copilot or ChatGPT mean that the model remembers my information, my code, any emails I ask it to write, presentations? Is it saving all my stuff that any of my team ask it, and potentially giving that to other users if they then ask the right questions? The short answer is yes, it can, unless you pay a subscription. So if you subscribe to Microsoft Copilot and pay them their monthly fee, or Google Gemini or ChatGPT, it doesn't save that information. So you can use them. If you use them for free, it's going to keep your information, learn from it, use it to train its models, and then generate that for other people if they ask the right questions. For instance, in our business at Cintia, we've been really successful mining ChatGPT for information about what our selected competitors of ours do in terms of sales process. How do they reach out to leads? How often? What sort of things do they write in emails? We can mine ChatGPT for this, and it gives us really good intel on our competitors, because at some point their staff were using that service in the open, unpaid.
And Gary, that's completely legal to do, right?
Yeah. That would be fine. Exactly.
So where staff use free products, you have to know that none of that information is actually kept confidential. Remember too, they might be using them at home. So in the office, they might be using MS Copilot, but at home, they may be on their family computer. They might also be using third-party tools. Gary touched on this, like AI inside Canva or Zoom Info or Fireflies or Otter. They all have AI assistants now. And unless you've read those terms and conditions, who knows if they're storing your information and learning from it, or using it for other users' products, other users' content to be generated. So unless you pour through those terms and conditions, it may well be that they're learning from and storing your confidential information. So Dave, your question was, isn't paying for MS Copilot for a corporate safe then? Microsoft Copilot comes as an easy selection for a corporate. Pay the fee. It keeps your information confidential, won't learn from it. So that's really great, right? Even though paying for it will stop these models from sharing your information with competitors or using it to train their LLMs, it's only one of the less concerning risks coming from these sorts of products.
And so do you use a private LLM to mitigate that risk of having potentially your data in the wild? And I guess the second question is, I got to think, you were talking about the AI risk assessment service that you guys do. How do you find out what employees are using on the corporate network that they're not to? And I think you were telling me there was one company said, you guys cannot use AI whatsoever, and they are all using it, but they were sneaking it. So how do you figure that out? Because I got to think that would be my greatest concern. There's the stuff that we're using AI to do, and then the scary part to me is my employees are using AI for stuff I have no idea about. And am I going to, how do I protect myself when they're doing that kind of stuff?
It's a big issue. I had a meeting last week with someone, and they're like, well, we've locked down we've told our staff they're not to use any AI product at all. And I said, well, okay, good luck. Release that. I said, on a Thursday night, one of your salespeople, for instance, is at home. It's 8:30. He wants to watch television or go to bed. He's got a report due Friday morning. You're telling me he's not going to quickly churn out some content on ChatGPT on his home computer and use it and just not tell you? And he kind of went silent and said, well, maybe they will. So it is controlling these applications is key. And we do have that risk advisory service where we have steps we run through, and I can talk about those today too. So, but the biggest concern with even paid AIs is there's a whole lot of issues, and Gary actually touched on one that I was going to talk about, which is this issue of bias and discrimination. The AI model, so Microsoft Copilot is just a relabel of ChatGPT, so there's no mystery there. It's the same thing. These AI models are trained on data from the internet. And most of the data on the internet is not very inclusive. So what do I mean? The data that these LLMs have absorbed is definitely racist. It has a white leaning simply because that's the nature of internet use over the past 30 years. It definitely has a white leaning. It's sexist. It's going to be very male dominated, and it's very Western skewed. So that's what the AI has learned. So if you picture the kind of persona that ChatGPT takes, it's going to be an aggregate of all of the internet use over the last 30 years, and there's definitely biases and discrimination in there. So any content the AI provides will reflect this. If you're an international company, it's really important to know this. If it's not carefully monitored, AIs are going to generate responses based on these biases that might lead to unfair treatment or inappropriate content for customers, employees, based on things like race, gender, age. Could result in legal and reputational risks for companies. The use of AI in recruitment is already, there's some legal action underway. Use of AI in performance monitoring, these things are critical because it has these biases built in. There's a few other risks in even paid AI services I'd like to talk about. There's a risk of losing internal skills. An over-reliance on AI to produce content, especially say in marketing or sales, means that your team will get less effective at producing that content. It tends to dumb down the content being produced by companies, which means less cut through potentially. Hallucinations for AI is still a huge problem, whether you pay for Microsoft Copilot or not. Stanford University released a study last month showing that generative AI tools, and in their case, it was for the legal industry, they make up false or misleading information between 17 and 33% of the time.
Wow.
So that's literally 1 in 3 responses have made up information, which in the legal industry is a disaster. But they're doing that across all their responses. So although we think that hallucination piece must be getting better, the evidence shows it's not necessarily getting better. So if all your team are using ChatGPT or Microsoft Copilot to produce content, who's fact checking that content? Who's checking all the material that they're putting out there under your company's name? There's an issue around ownership of intellectual property. So all AI generated material is unable to be copyrighted. You can't own that material legally, so you can't claim you own it. So if you sell it, if for instance you're a consulting firm and you use AI to generate reports or findings or recommendations, and you're submitting it to a client and billing them, and you don't declare that you used AI in that work, you could be committing a fraud. You're actually selling something that you haven't actually generated yourself and have legal rights to. And finally, the biggest issue with Microsoft Copilot is permissions. For a staff person, when a company turns on Copilot, the AI is given access to all of the organizational data that company has, and its signal for what they're allowed to, each user is allowed to see, is based on their Active Directory setup. So typically, AIs look across Active Directory and say, well, this role is entitled to see all of these documents. That's usually based on an individual's job title. So the title dictates what they're allowed to view. Now, why is that a problem? Each user, each salesperson, for instance, can't log into some other user's OneDrive, SharePoint, emails, and the like. But the permissions say they're technically allowed to see the documents from, say, all the other salespeople. The AI just knows that piece. So when companies set up this global access to documents based on tiers or a hierarchy, salespeople can see all of the documents and information from other salespeople, but let's say not sales managers. So imagine a salesperson's generating a proposal for a client, and to do so, the client shares confidential information and asks the salesperson to sign an NDA. The rep knows the information is now bound by confidentiality. The AI only knows that within that company's permission structure, all reps can see that stuff. It won't recognize that it's bound under an NDA automatically. And so it can use that secret information to create a whole lot of other proposals for all the other reps, possibly even a competitor of the original company, breaching the NDA. Another big example that resonates when I tell people is department heads. Typically, department heads are allowed to see documents owned by other department heads, for instance. Obviously, the sales director can't sign into a finance director's OneDrive and see their spreadsheets and reports. But the AI only knows that they're all technically allowed to see data at that level. So the sales director could ask Copilot about salary information and finds it's going to tell him specifically what each of his colleagues are paid due to the permission. So these sorts of risks are serious risks, can lead to losses. And when a company just flicks a switch and turns on Copilot, they usually don't do a deep dive into these things, Dave.
Yeah, let me ask one more question, then I'm going to jump into our where we're going back and forth.
Gary was going to add.
I was going to add two things.
Go ahead, Gary. My apologies.
Yeah, I want to add two things what David said, which was great. So in terms of what David was saying about contracts and breaching your obligation to your own client, that's a big issue, because you may have a contract which says everything that we produce for you, client, you own, and it'll all be an original work of authorship. Well, if you're using AI to create that deliverable, as David just mentioned, they may not own the output, because the output cannot be copyrighted and it's not an original work of authorship. So you may have breached your own contract to your client by using AI. Second thing, to comment on what David was mentioning, I've seen a lot of companies start to put in place AI employee policies. Just like you have a policy about proper email usage and bring your own device to work and anti-sexual harassment and all other policies in the company manual, I'm starting to see AI policies. Sometimes the AI policy says, just don't use AI, which is pretty straightforward. But other times it's a little bit more nuanced. It says you can use AI. It shouldn't be the sole source of factual information. You need to be transparent with the company clients that you're using AI. David mentioned you don't want to be fraudulently billing your client. If your client thinks it spent 50 hours doing a project, but it took you 50 seconds, you don't want to bill them for 50 hours. So put it in place an AI policy that makes sense for your type of organization may make a lot of sense.
That's a great thing. And I think that's the lead into my next question for David. So I think I got a little bit of an idea how I legally protect my business. But now from a non-legal perspective, as a CEO of an AI startup, how do I mitigate that risk, Dave? How are you looking at it from a non-legal, just business straight perspective? What are you doing for your clients?
So there's no way, if you're going to make use of AI, there's no way to eliminate all risk for the business. But as Gary said, you can definitely mitigate the risk from using generative AI. And as I said, as a blatant plug for our services, we do this for companies. But let me give you a checklist of what we would do. And it's part of our risk advisory audit. So in our case, we do the work, but you can do a lot of these elements yourself. So number one, and Gary mentioned a couple of these, you've got to know the scale of the risk. So what do I mean? You need a complete detailed audit across every individual team member, covering what AI they're actually using, any and all use. Just how widespread is it? what AIs are being used. Possibly you know about Microsoft Copilot or ChatGPT or Gemini, but you need to also know about any other third-party product that's offering AI assistance built in. And there's a lot of them. There were 6,500 in the last 12 months hit the marketplace. So your team may be using these things, and you need to actually do an audit and make a list of what all of these are, firstly to identify the cost, but also to get a clear picture of what the risk really is. How much confidential information is maybe being leaked out there to some of these third-party products. The second point, and Gary did touch on this as well, is we would suggest you generate a formal policy about AI and use of AI in your business. So determine what you will and won't allow in terms of the use of AI. Make sure everyone's aware of the policy and make sure they sign it to say they'll follow it. So you've got some controls in place, because the worst thing, I'm not a lawyer, but the worst thing you could do is stand up when there's an incident in court and say, yeah, we really didn't know what was going on in our business. The third point that we would do is, in every bit of content produced by your team that goes to any other person, whether that's a customer or internal use or anyone, any stakeholder, ensure that they declare where AI was used in preparing that material and to what extent. Could just be a flag on sensitive material at the bottom. That then triggers your systems to decide whether you need to fact check that, quality check it, and minimize the risk of what that document can do. So if it's flagged, at least some other person can look it over and do some fact checking and quality checking. If it's not, who knows what gets put out there under your company's name.
Yeah.
All right. So we've got some great questions. I'm sorry, Gary, did you want to point there before I jump in? Sorry, go ahead.
Yeah. And I've seen some services, especially in the legal space, and I'm sure it's in other industries as well, where it's AI technology, but within a confined universe. So it's only searching within a universe that they're comfortable that the output will be reliable. There are many legal services out there, Lexis and Westlaw, that are now building these tools for the legal industry that only use AI within their defined universe of existing documents and cases, so that you can feel comfortable about the output. So that's also an option.
Yeah.
I've got a bunch of great questions here, and just like last time, I have a hunch we're going to run way over here. So Miss Sonia Kastner asked about, what about AI being regulated and replacing human jobs? I think we all know that's happening. That's just reality. So her question is, I have so many friends in advertising who have been replaced by AI. It's a very sad state of affairs. Yeah, I think it's just reality, right? I mean, Dave, go ahead.
Yeah, I think I get that question all the time, and in our sphere, we tend to be working with companies with sales teams and service teams and marketing teams, and we get that question a lot. And I mean, for the last 18 months, I've kind of couched my responses to not sound too harsh. But the reality is the world is a different place now with generative AI. There are loads of risks. It's not the panacea that everyone thinks it is, but it is going to take away a lot of jobs. I had a debate on the weekend with some friends around that. There was some stats came out that someone made a claim, it might have been Elon Musk, that 50% of jobs will be replaced by AI in the next sort of 12 months, 2 years. Now, 50% sounds a lot, but as someone said, well, the biggest employers are, say, hospitality. But when you look at what, say, McDonald's is doing with automation in their stores now, they've got robots flipping burgers, they've got screens, and they don't even have to put people on the registers. You could definitely see fast food being completely run by automation and AI, fast food restaurants. Once you start running through industries, I think it just means we all have to face the fact that in choosing careers now, you have to consider, is it something where a role could be done by a really clever AI? Because the month-on-month improvement in the quality of the AI services is just mind-boggling. We're right at that bleeding edge, and I don't think the general population just realizes how far along these technologies are. So yeah, jobs are going to be at risk, a lot of jobs. And I don't know what we can do about that.
So I think the key is going to be blended AI. To Sonia's question, it's the people that are able to utilize AI to improve their skill set, upskill. They're the ones that are going to do better. The ones that ignore AI and hope it's going to go away are going to be the ones that suffer. So I think that leads us to our next question, Gary. If we generate reports leveraging AI, but a human gets to check the validity of the data, blended AI, then who's liable?
Well, it depends upon, what this report is for. Is this some internal item? Is this a deliverable to a client? Do you have a contract with that client? It's going to turn on what your obligations are, regardless of the AI at that point. So say you have you're a consulting company, going to David Forder's example earlier, and you're developing a report for a client. I'm sure your contract with the client says that you're responsible for the reports you deliver. So whether or not you did it solely with AI or a blended version of AI and a human, you're going to be responsible for that report that you're delivering. Now, I have seen some folks in some industries, and to our prior question, particularly in creative industries, that when the parties agree that AI is going to be used for some sort of deliverable, they sign an addendum to the contract and literally just lay it out very, very clearly that we're going to be using AI. We don't know if the output's going to infringe someone's rights. As between the two of us, you can own the output, but as between you and the rest of the world, I have no idea. So I think having that upfront conversation with a client really makes a lot of sense, and it may result in some amendment to your contract in order to enable you to use AI for that deliverable.
So it says you definitely got to cross your eyes, cross your T's and dot your I's on all this stuff and really look at that 360 exposure perspective, not just from the business, but from the legal perspective. And then, like you said, what are those other things that we're not thinking about? What are your clients doing and how is that interaction taking place? So Brian Wood, MBA, Binghamton University, had a couple of really interesting comments on how transcriptionists were being replaced by AI systems. Brian, I think you're right. So let's jump into your next questions. I got the same question for both of you. So Dave, when you think about your AI business crystal ball and you're looking out in the next 6 months to 12 months, what do you see coming along that people probably either have no idea that is even possible, or there's something that's going to be coming along that they really have to pay attention because it's going to dramatically impact them? And Gary, from a legal perspective, I'm going to ask you the same question. Dave?
Well, the short answer is at some point in time in the near future, every company is going to have their own LLM. So the ChatGPT, the Microsoft Copilots, the Google Geminis are racing to secure corporate subscriptions for their AI services because it's an easy flick a switch and you're on AI. As I said, that doesn't eliminate much of the risk, but it's easy and simple, and it gives a board plausible deniability. Like, yeah, okay, we've got the AI thing ticked. We pay for Copilot. In the near future, everyone is going to, at some point in time, every company is going to have their own LLM and not use these third-party AIs for a whole lot of reasons. Data privacy, continuity. If you use commercial AI providers, they're subject to market forces. They may have outages or shut down. Google Gemini has been down a couple of times in the last few weeks. The quality of the answers of a private LLM will be far superior. You can train that AI, your own AI, on your own industry-specific data sets. You can also direct the LLMs to tell you when they don't know something. So commercial AIs will always give you an answer. They'll make one up if they don't know it. A private LLM can be directed to say it doesn't know if it doesn't have that data that it can draw from that's accurate. A private LLM is an asset, not an expense. So again, it makes a lot more sense to be investing in one that you own and control, and you can direct the responses. It gives you visibility and recognize costs. You know what it's going to cost. The ChatGPT, the cost of providing ChatGPT and Copilot to consumers is actually 3 times what they charge at the moment. So at some point in time, companies are going to be paying a lot more for that service. They can only top that up for so long. So a private LLM gives you an enormous number of opportunities. So I think, Dave, in the next 12 months, 18 months, 2 years, that's the big trend that's coming. And as a plug for Sentia, that's what we do for clients right now. So you can get ahead of the curve and get a point of difference.
So Gary, you talked about what's happening in Europe. You talked about the Colorado and Utah, the states is coming on. You talked about the Fed kind of tiptoeing around. You talk about California and their data privacy laws already on the books. So from your legal crystal ball, what do you see in the next 6 to 12 months that people need to pay attention to? And from a business perspective, what do they need to be scared about? I guess scared or reduce their risk exposure.
Yeah, I think we're going to see, just like it happened in the privacy world, we're going to see more states regulating AI. And I think that each law is going to be different, and there's going to be disconnects
It's
between
going
the
to get
different
messy.
states, which will make compliance a real challenge. But I think we're also going to learn as we see these laws come out that there's going to be common themes about things to be concerned about. I think you're going to see a lot of talk about this algorithmic discrimination, about a heightened concern if the AI is for consequential decision making versus just a general purpose. And that's kind of happened like in the privacy space. We've all learned that all the state laws are starting to treat sensitive data differently than other personal data. So I think in AI, we're going to see common themes come about in these laws, and that will inform companies about building their systems that, my AI system is helping someone decide where to take a fun vacation that's maybe low risk, versus my AI platform is going to help someone in their hiring decisions that's high risk. I need to do more things to make sure that I'm not going to have any problems that are going to trip up these new laws.
So that sounds like you're prescient, because you talked about those 4 in the EU AI buckets, right? Those 4 buckets you talked about, and you pretty much just said it. So it sounds to me like you're pretty confident that's the way the US is going to head to as well.
Yeah, I mean, I don't know if we're going to get to the point of that highest level where there are going to be some that are absolutely prohibited, that are illegal to do at all. It's possible. We haven't seen that yet, but I think that they will see greater oversight for anything that's going to be used in healthcare, finance, employment, legal rights, family law, things like that. Any sort of AI platform that goes into those sensitive areas, I think is going to be much more highly regulated.
So that makes sense to me. So when I'm looking at my my clients, and I'm trying to figure out, well, when should I actually bring in AI legal services such as yours, or when I'm going to have the same question for Dave, what are the things that actually scream to the CEO of, let's say, a 250 person company where they need to talk to Gary, right? Is it they're using AI as a course of their business, or is they think their employees are using it but they don't know? I mean, when is it when that AI legal person like you should be brought in to kind of cover your butt kiss, if you'll pardon the phrase?
Right. I mean, look, not to make it a big pitch for the legal industry, but you want to do so early. And it's sort of like again, I keep making analogies to the privacy world. There's a concept in the privacy world called privacy by design. And that means building privacy compliance into your products and services early in the stage from the ground up. So I think with AI too, you really want to look at the legal implications early on. And look, it may not be some massive big project and undertaking, may just be a quick conversation with your trusted counselor about things you need to be concerned of before you start jumping in. So I do think you want to have those conversations early, at least the issues on the table, and then realize, are we in a risky area or are we in a non-risky area where we can just run straight ahead?
Got it. So Dave, same question to you. So if you're consulting with a new client, they come in, what is it from a business perspective that you look at and say, look, you know what, this is a concern? What are the 2 or 3 things that you look for when you're trying to help a client?
I think it depends on the industry that the client's operating in. I think if someone runs a chain of cafes, the risks of using AI are fairly easy to quantify. The CEO can probably determine what they are. A quick email, and I'm happy to talk to anyone about these things casually at any time. You can lock that down pretty quickly. If you're running a chain of cafes, it's probably not an enormous risk. You probably need to check in terms of recruitment and employee management. That's probably the biggest risk. If you're working in the health space or finance, or you're looking anywhere where you're producing a lot of content that goes out into the market, and any of that content or any of the data that you get from clients is private or sensitive, then you need to really lock down that AI piece. I've been amazed by, for instance, Fireflies. I'll pick on some third-party apps. That's a great note-taking app. It's all over the place. Otter does this as well. Canva does this as well. Adobe has the same thing. So they've all introduced amazing AI assistants in their technology. And so a company may come to me and say, look, I've told everyone not to use AI. And I'll say, but we're in a meeting and you're using Fireflies as a note taker. Did you know that then takes this transcript and generates insights with AI? And they're like, no. And I said, so your company's actually using AI now, and you didn't realize it. Now, do you know if Firefly's trained their LLM on your meeting transcripts? Do you ever have private meetings where you don't want the information to be public? And they'll say, yes. I'll say, well, do you know? And I actually don't know the answer, but it's not the point, right? You need to know, if you're using third-party apps, what are those LLMs, what are those third-party software packages doing with your data? What's in those terms and conditions? Have you given them the rights to that information? Now, Fireflies is a pretty responsible business, and I'm sure you're perfectly safe, but I would be checking. And who's to say that some nefarious group doesn't buy Fireflies and decide to monetize that LLM at some point in the future with all of that trained data, or Otter or Canva or anyone, or Adobe for that matter? Like, you need to be really aware, no matter what size company you have, depending on your industry, you really need to lock down this stuff and know exactly what tools are being used by who. Where does that data go? What do those companies do with it? What are they bound? What are you allowing them to do with it under the terms and conditions? Because you just never know.
And you can't claw it back, right? I mean, once that data is out there, it's.
And meeting transcripts sound minor, but there's a lot of sensitive information gets.
Oh, heck yeah!
On meetings, and there's lots of note-taking apps now. How do you know where that is? Like, where do those notes go? And yet we'll all do it without really thinking twice about that.
And that's what Gary keeps bringing up. We are doing so many things that we have no idea what those consequences are legally. It's pretty scary. It's pretty scary. So, guys, I like to run a really tight ship here. I promised an hour, and I know how busy both of you are. So I'm going to end with one question for each of you, and I think it's really important. So if I could do a cliff notes of this meeting and listening to you guys with all the amazing things you could say, Gary, start off. Give me 3 things that you want your listener to say. I just spent an hour with Gary. What should my 3 takeaways should be?
I would say, number 1, realize there are AI laws here right now. Number 2, make sure that you've got to look before you leap in jumping into AI. And another cliche, an ounce of prevention is worth a pound of cure. And number 3, I'm still a big proponent. It's a positive. AI is going to be fantastic in many ways. You just need to find the right way to implement it for your business.
It's a new tool in the toolkit. You just got to figure out how to use it, right? So, Dave, could you tell me the next 3 things that you think, if they listen to you from a business perspective, they should remember?
Well, I think it's about some of those steps in doing a risk audit. So get a clear picture on exactly what AI tools are being used by your team, no matter what industry you're in. Make sure you have a policy in place saying what's acceptable, because if you don't, you're behind from the start. And then think through where your information could end up or where it's going. The key, I think, is to end up finding a trusted advisor. I'd love it to be us at Accenture, and you can find me on LinkedIn and my team. But whether it's me or someone else, have someone as a go-to, because the AI space is changing rapidly, a bit like the legal area in terms of AI. And you need someone who lives and breathes it like we do on my team. So that, and we don't have to charge a lot of money to do this. Just make sure you have someone that's on top of this area, because there's a lot of innovation going on. And if you're not across it, you're either going to be left behind commercially or otherwise expose yourself to a normal risk. So it's kind of a lose-lose unless you get on top of this tidal wave.
So the 3 things are: get on top of it now, understand exactly what your employees are using, and 3, make sure that you have a plan going forward to protect yourself. That's the 3 takeaways I get. I appreciate both of your time. Obviously, amazing, exciting stuff. Just like last time, we had hundreds of people signed up and viewing this. So this is obviously a topic that everybody's really interested in. Gary, I know that Davis and Gilbert is where you work, and that would be the best place to catch you for advice and legal counsel.
Exactly. Going through our website, dglaw.com. It's always a good source.
And Mr. Forder?
LinkedIn is probably the simplest way. We obviously Centia.online, Centia.community, but LinkedIn's easy. You'll find us there. And if anyone wants to leave questions in the meeting chat here ongoing, my team keeps an eye on it. So we'll generate some answers for you.
All right. Well, thank you kindly for both of your time and participation. Obviously, based on the questions and stuff, we've gotten another very successful live stream. I appreciate your time, and have a great day, gentlemen.
Yeah. Thank you, David. Thanks, Gary.
Bye. Thank you.
Bye-bye.
Bye-bye.